A single voicemail recorded just before midnight, a subpoena that arrived 32 hours later, and a deadline set with surgical precision. What unfolded inside that hearing room wasn't a misunderstanding, but a perfectly timed sequence that exposed intent, coordination, and something far more dangerous. Because the real story isn't what Steve Miller said, it's what he knew before anyone else did. If someone orders evidence destroyed before the law can preserve it, is that coincidence or proof they were warned? This is not a routine congressional hearing. This is a controlled exposure of a timeline that does not allow for accident, and at the center of it sits Steve Miller. Under oath, facing a sequence of events that align too precisely to be explained away, because the issue here is no longer whether records were targeted, it is whether the timing itself proves foreknowledge. Jamie Raskin does not begin with accusation, he begins with structure, because structure is harder to deny than intent, and he lays it out without interruption. March 28th, just before midnight, a voicemail left by Miller instructing Mr. Webb to delete server logs, email backups, and contractor payment records, not selectively, not cautiously, but completely, and not quietly, but in a way designed to look routine. He does not pause to ask if the voice is real. He establishes that it is, and then he moves forward, because the voice is only the entry point, not the argument. March 30th. 32 hours later, a subpoena is issued by this committee, demanding preservation of those exact categories of records, not similar categories, not adjacent ones, but the same data sets Miller had just ordered erased, and now the timeline begins to compress, because once those two dates exist side by side, explanation becomes limited. Raskin does not fill the gap with speculation, he fills it with sequence. Access to internal investigative material on March 27th, a full download of a subpoena draft, including targets, scope, and timing, followed by a midnight call on March 28th, followed by a destruction order with a Friday morning deadline, followed by a subpoena on March 30th. 4 points. 1 line, no deviation. He does not raise his voice because the alignment speaks without amplification. You did not say preserve, Raskin states. You did not say prepare. You said delete everything. And you gave a deadline that exists for one reason only, to act before legal preservation attaches. There is no interpretation added, because none is required. You were not responding to a subpoena, he continues. You were acting before it arrived. That distinction is not rhetorical. It is legal, because acting after a subpoena invites scrutiny, but acting before one, with knowledge it is coming, suggests something else entirely. Miller sits still. No correction. No denial. And that absence does not weaken the structure, it reinforces it. Because in a hearing built on sequence, silence does not create doubt, it confirms that the sequence stands uncontested. And once the sequence stands, the next question is no longer optional. Who told him? Raskin does not circle back to the question, he tightens the timeline instead, because this is no longer about what Miller says, it is about what the sequence proves, and once the sequence locks, intent stops being an opinion and becomes a conclusion. March 27th, he says, our internal system records access to an active investigative file on DHS contractor oversight, not a casual view, a full download of the subpoena draft, including targets, scope, and execution timeline. He doesn't pause for effect. He pauses because the record speaks for itself. March 28th, just before midnight, you call Mr. Webb, and then you leave a voicemail. Your words. Delete everything. Server logs from February through April. Email backups. Contractor payment lists. Make it look like routine maintenance. Complete it before 9 a.m. Friday. He lets the instruction sit as evidence, not rhetoric. March 30th, this committee issues a subpoena demanding preservation of those exact records. Now the structure is complete, and he makes it explicit. Access on the 27th, deletion order on the 28th, subpoena on the 30th, deadline set before legal preservation attaches. He leans forward slightly. That is not reaction, that is coordination. No one interrupts because there is nothing to dispute in the order itself. You didn't say, if they ask, Raskin continues. You didn't say, be careful. You said, delete everything. And you gave a deadline that exists for one purpose only, to get ahead of a subpoena you already knew was coming. He shifts to the next layer without slowing down. Between February 14th and March 28th, you called Mr. Webb 43 times, most of those calls after midnight, and according to sworn testimony, every one of those calls was about how to hide financial records from congressional oversight. He doesn't ask if that's true. He states it because it's already in the record. So let's remove coincidence from the equation, he says. You have repeated late-night calls about hiding records. You have a full download of a subpoena draft inside this building, and within hours of that download, you issue a destruction order with a deadline that perfectly precedes legal preservation. He taps the document in front of him. Those are 3 independent data points, and they all point in the same direction. His voice remains even, but the pressure increases. Coincidence does not produce alignment at that level. He doesn't wait for a response. Panic does not produce instructions like, make it look routine. Another layer closes. Preparation does. He looks directly at Miller now. You were not guessing. You were not speculating. You were acting on information you were not authorized to have. Then he sharpens it further. Because without that information, this timeline falls apart. Without that information, there is no reason to set that deadline. Without that information, there is no reason to call Mr. Webb at midnight and tell him to erase everything. He straightens. But with that information, every action you took makes perfect sense. There is no raised voice, no accusation beyond the structure itself. So I'm going to ask you again, Raskin says. Who gave you that information? Raskin doesn't repeat himself after the question. He lets it hang because at this point the room already knows there are only 2 possibilities left. Either Miller answers and exposes the source, or he refuses and confirms that the source is real and worth protecting. Miller says nothing. Raskin nods once, as if that silence has already been entered into the record, and then he moves to the next layer, not away from the question, but directly through it. Mr. Webb testified under oath, he says, that in a call just before that voicemail, you told him someone senior had warned you, someone who knew exactly what Congress was investigating. He doesn't dramatize the word senior, he lets its implication do the work. Mr. Webb asked you who, Raskin continues, and you refused to say. You told him it was someone with access. He picks up a document, not to read it, but to anchor the statement. That testimony is now part of the record. He looks back at Miller. So now we're not dealing with speculation. We're dealing with your own statement to a cooperating witness that you had advance notice from someone inside the system. Miller's attorney shifts, preparing to intervene, but Raskin doesn't slow down. We pulled the access logs, he says, and the individual who opened that investigative file on March 27th didn't just view it. They downloaded the entire subpoena package, targets, timeline, and scope. He takes one step closer. That file was accessed from a specific office inside this building. The room tightens again, not because of volume, but because the abstract has just been narrowed to a location. A specific terminal, Raskin continues, at a specific time, tied to a specific user session. He doesn't name the office, and that omission is deliberate. Which means this is no longer a question of whether someone had access, he says. It's a question of who used that access to tip you off. Miller shifts slightly in his seat. It's the first visible break in posture, and it doesn't go unnoticed. Raskin locks onto it. You understand what that means, he says, voice still controlled. This is not just about obstruction anymore. He lets that line land. This is about a breach inside a congressional investigation. He sets the document down. Someone inside this building accessed a live subpoena draft, downloaded it, and within 24 hours, you issued a destruction order that matches that draft exactly. He doesn't raise his voice, but the implication sharpens. That is not a leak of opinion. That is a transfer of operational detail. Miller's attorney stands. My client invokes... Sit down, Raskin cuts in. Not loudly, but decisively. Because at this point, interruption is not procedure. It's delay. Executive privilege does not apply to communications that facilitate the destruction of evidence, he says, closing that door before it opens. He turns back to Miller. So let's be clear about the position you're in right now, Raskin continues. We have your voicemail ordering deletion. We have 43 calls discussing concealment. We have a cooperating witness who says you were warned by someone senior. And we have access logs showing that a subpoena draft was downloaded from inside this building hours before your call. He pauses, just enough to mark the transition. That is a closed loop. He leans in slightly. The only variable left is the name. Silence again. But now the silence is different. It is no longer just refusal. It is containment. And Raskin makes that explicit. You are not protecting yourself, he says. You are protecting whoever sat at that terminal on March 27th. Raskin doesn't escalate his voice, he escalates the consequence, because by now the facts are no longer being built. They are being sealed, and the silence in front of him has already done what testimony could not. He looks at the stopwatch, then back at Miller, and what he says next is not a question. It is a boundary. Mr. Miller, I'm going to give you a final opportunity, he says, steady, controlled, because once this moves forward, it does not come back. He doesn't wait for agreement. We are at the point where the record is complete enough to stand on its own, he continues. Voicemail on March 28th, subpoena on March 30th, 43 calls discussing concealment, and access logs confirming a full download of our investigative file on March 27th from inside this building. He taps the table once, not for emphasis, but to anchor the sequence. That is evidence of obstruction, he says, and evidence of a coordinated leak. Miller remains still. No answer. No denial. Raskin nods slightly, as if confirming what the silence has already established. Then let's be clear about what happens next, he says. He turns toward the committee, but his voice remains directed at the room, at the cameras, at anyone watching who understands what these pieces mean when they are placed together. This is no longer a matter of incomplete testimony, he states. This is a matter of completed evidence. He straightens. We have a federal official issuing a directive to destroy records before a lawful preservation order takes effect, he continues, and we have a data trail showing that directive was timed with information accessed from within a congressional system. He pauses, letting the structure settle into something irreversible. That is not a procedural failure, he says. That is a breach of the oversight process itself. He doesn't soften it. Because if someone inside this institution can access a live investigation, extract its targets, and relay that information in time for evidence to be destroyed, then the integrity of every investigation that follows is called into question. The room is silent, but not empty. Every line now points in the same direction. Raskin doesn't look back at Miller immediately. He lets the implication expand beyond the witness table. "This is not about party," he says. "This is not about narrative. This is about whether the system designed to enforce the law can be manipulated from the inside." Then he turns back. "And right now, Mr. Miller, you are the connection point between those two failures." He takes a breath, measured, controlled. "You had the instruction," he says. "You had the timing. And according to sworn testimony, you had the warning." He doesn't raise his voice, but the conclusion is unmistakable. "And you chose to act." Another pause. "Long enough for the weight to register." "So understand what your silence means," Raskin continues. "It does not protect the person who warned you. It confirms that person exists." He steps back slightly, shifting from interrogation to record. "I move to enter the voicemail recording, the phone logs, the access records, and the cooperating witness testimony into the official record," he says. "And I move to refer this matter to the Department of Justice for investigation under federal obstruction and conspiracy statutes." There is no resistance, no hesitation. The motion carries. And with it, the hearing changes shape. Because what started as a question has now become a referral. What started as testimony has now become a case. Raskin gathers the documents in front of him, but before he sits, he leaves one final line, not directed at Miller, but at the record itself. "The evidence connects," he says. "And the only thing missing is the name." He doesn't need to say more, because the next phase does not depend on this room anymore. It depends on who accessed that system on March 27th. And when that name is identified, this will not remain a hearing. It will become prosecution. If you followed this from the beginning, then you already understand what is at stake here. So don't disengage now. Like the video. Comment what you think really happened behind that silence. Share this with someone who still believes this kind of timing is coincidence. And subscribe, because when that name is revealed, it won't just close a case. It will expose a system,